This is another lecture, short lecture on professional responsibility and conflicts of interest under Model Rule 1.7. And here we're going to be talking about additional special considerations when we have joint representation or common representation. So you're representing co-defendants, co-plaintiffs, or a group of people that want to form an entity together, like a business together or something like that. And a couple of family members or a husband, a married couple who want you to do their wills and so forth. And now we've already been talking about this with some of the other conflicts of interest rules focused on what happens when you're doing that in a litigation setting or a transactional setting. But we have some additional considerations mentioned in comments 29 to 33. And we are getting to the tail end here, almost done with Model Rule 1.7. As I explained at the outset, this rule has the most comments of any rule in the model rules. It's the most complicated. It's also the most heavily tested rule. And so we have to spend a lot of time covering 1.7 conflicts of interest. Okay, comment 29. In considering whether to represent multiple clients in the same matter, a lawyer should be mindful that if common representation fails because of a potentially adverse interest, and it can't be reconciled, then the result can be additional cost, embarrassment, and recrimination. Recrimination means the blame game. Everybody starts blaming everybody else for what's going wrong and ultimately will blame the lawyer. And so keep in mind that when you're doing joint representation or common representation, as it calls it here, representing a group of clients together who see themselves as on the same side and wanting to join, having shared legal interests, and that's why they want to use the same lawyer. If at some point they have a falling out and are suing each other or reach an impasse in how to proceed or something like that, and you can't bring them all together and form a consensus between them, it's going to end up being even more expensive to bring in separate lawyers for them later on to fix the mess. And it's going to be embarrassing for you. And there's going to be a lot of blame and accusation, and it can really be bad. So ordinarily, and we've mentioned this before, the lawyer will be forced to withdraw from representing all of the clients if the common representation fails. So again, if John, Paul, George, and Ringo come to you and you're trying to represent them as a group in forming their record label, that may seem all well and good, and they may be saying at the time, look, we're all in agreement. We're going to share everything and divide the royalties equally and make all our decisions together, and everybody, it's one person, one vote, and so forth. But if one of them at some point revokes their consent to the conflict of interest and has a falling out, it's not clear that you're going to get to just continue representing the rest of the group or your favorite one of the group of clients. You may have to withdraw from representing all of them. And in some situations, the risk of failure is so great that multiple representation is plainly impossible. In other words, shame on you for even trying. And here's an example. For example, a lawyer cannot undertake common representation of clients where contentious litigation or negotiations between them are imminent or contemplated. So if two people come into your office and say, we want you to represent us because we're getting ready to sue each other, then you probably should say no, right? That's what we're saying is, why did you think that you can't just say, okay, but you're gonna have to consent to the conflict of interest. They're already talking about suing each other. They should be sitting in different lawyers' offices. Moreover, because the lawyer is required to be impartial between commonly representing clients, representation of multiple clients is improper when it is unlikely that impartiality can be maintained. And so if you're going to end up favoring one, why would you do that? Because one of them is paying your bills, right? So this is the problem. One of the other problems that comes up with common representation is that a lot of times there's one person in the group who's actually has agreed to pay for the lawyer for the time being, or spot everybody else and they're going to pay him back, or something, or it's his contribution is to hire the lawyer, or her contribution. And guess what? That's the person that the lawyer tends to favor, is the one paying the legal fees. So generally, if the relationship between the parties has already assumed antagonism, the possibility that the client's interest can be adequately served by common representation is not very good. Other relevant factors are whether the lawyer will subsequently represent both parties on a continuing basis, or whether the situation involves creating or terminating a relationship between the parties. So if you're creating a relationship between the parties, and then you're going to be starting to do legal work later on for them and so forth, you need to think about this. Are you hoping to be the lawyer for everybody in this group for everything that comes up? And a lot of lawyers would say, yes, I want. That's why I'm representing the group, is even though they're all sharing me right now, I have 4 people that I'm their lawyer, and when they have other legal needs, they're going to call me, let's say. Well, the problem is that you are now setting yourself up for future conflicts of interest. And so you should keep that in mind. We also have this issue with privilege and joint representation. A particularly important factor, this is comment 30 to Rule 1.7, a particularly important factor in determining the appropriateness of common representation is the effect on client-lawyer confidentiality and attorney-client privilege. This is mentioned twice in the comments to Rule 1.7. They want to make sure you understand, and I think that you should be aware that this is likely to come up on your MPRE. The attorney-client privilege issues related to conflicts of interest and common or joint representation. With regard to the attorney-client privilege, the prevailing rule is that as between commonly represented clients, the privilege does not attach. And hence, it must be assumed that if litigation eventuates between the parties, the privilege will not protect any such communications, and the client should be so advised. So I've used the John, Paul, George, and Ringo before. Let's use another example, and let's say that Jerry and Elaine and George and Kramer come to you, and they want you to do their some sort of legal work for them. They have a great business idea, and they want you to set this up. Now, in the future, you're the client for Jerry and George and Elaine and Kramer together as a group in a common representation or a common legal cause that they're pressing. That's fine, and in the future, if other people are suing them as a group or suing one of them, any communications you have with them will be protected by attorney-client privilege, which means you won't be forced to disclose it during discovery in other proceedings. On the other hand, if at some point litigation arises between, let's say, George and Kramer, and so one of them decides to sue the other over something else that happens, and for some reason the conversations that they had with you as their lawyer back in that joint representation are relevant to the new matter, you could be forced as a lawyer to share stuff that would otherwise be privileged, to disclose it during discovery, and it could be admissible at trial because attorney-client privilege won't apply when you have a group of clients together. By the way, I'm going to say this again when I get to our whole lecture on attorney-client privilege. There's something I see on television shows and movies doing a lot lately. That they did this in Breaking Bad and in Better Call Saul. This idea that if somebody gives the lawyer $1, that then there's attorney-client privilege, and that's not a thing. I know Hollywood scriptwriters think it's a thing. There's even some cases out there with lawyers who thought that was a thing, and that's not a thing. If somebody talks to you, it doesn't matter if you end up declining the representation or you do the case pro bono. The exchange of money is not what defines whether attorney-client privilege will apply to the conversation. If they're talking to a lawyer for the purpose of obtaining representation and it was confidential and none of the other exceptions to privilege apply, it will be privileged whether they gave you $1 or not. So if you've seen that or gotten that in your head from watching television shows, please get it out. That's not a thing. Okay, as to the duty of confidentiality, continued common representation will almost certainly be inadequate if one client asks the lawyer not to disclose to the other client information relevant to the common representation. So I've given the example before of the married couple who comes to the lawyer and wants the lawyer to do their wills. And it's supposed to be a straightforward matter. Each one is leaving everything to the other one. And if they both go, everything goes to the children and so forth, or heirs, or their favorite charity. And then one of these spouses calls the lawyer and says, by the way, I had an affair long ago, or I'm having an affair. I have another person I was married to in my youth and never really finalized the divorce. I've seen there's cases where this has happened, and then the lawyer finds out and they say, but please don't tell my spouse, my current spouse, or I had a child many years ago and I've never told my spouse about it. And so forth. You're not allowed to keep those types of secrets from the other person. So it's going to be open. You need to tell people this. If you're going to represent even a married couple in a joint representation, you might want to give them a heads up. By the way, if one of you tells me kind of some big secret that's relevant to the representation, I have to tell the other one, or I will have to very awkwardly withdraw from representing both of you, and without giving an explanation. And so this is so because the lawyer has an equal duty of loyalty to each client, and each client has the right to be informed of anything bearing on the representation that might affect the client's interests, and the right to expect that the lawyer will use that information to the client's benefit, right? So each spouse has a right to think that you're going to tell them what's going on. Again, if John, Paul, George, and Ringo come to you to start a record label, and one of them tells you some big secret, like, you know what, I've been having an affair with this other, with Ringo's wife, or something like that, some deep, dark secret, or I always hated this guy, or I'm the one who scraped the paint off his car one day, or something. Everybody else, if it relates to the representation, then everyone in the group that you're representing together has a right to know that. They all have a right for you to be just as much their lawyer and to look out for their interests as much as the other. So you don't get to keep secrets between them. And then we're going to have an exception to that. But you should, at the outset of the representation and as part of the process of obtaining informed consent, advise each client that information will be shared and that the lawyer will have to withdraw if one client decides that some matter material to the representation be kept from the other. Now, I've been giving kind of innocuous examples, but now I want you to imagine that you're representing members of a violent criminal gang or the mafia or something like that. Again, you're going to have to, you could have a very difficult situation where if you find out some secret information from one of them and it's relevant to the representation, you will have to tell the others. There's some rare circumstances where it may be appropriate for the lawyer to proceed with the representation when the clients have agreed, after being properly informed, that the lawyer will keep certain information confidential. And here's the big example. And it's hard to think of another example besides this, but here's the example that you should know that I think you're likely to see as a test question on the MPRE. The lawyer may reasonably conclude that failure to disclose one client's trade secrets to another client will not adversely affect the representation involving a joint venture between the clients, and agree to keep that information confidential with the informed consent of both clients. And so to give I'll give an example. The old story is that Coca-Cola has a trade secret on its formula to make Coca-Cola taste the way it does. If you've ever bought another brand like the Kroger brand or Walmart's store brand or HEB or something like that of cola, no one thinks it tastes like Coca-Cola. No one's ever been able to get the taste, and Coke didn't patent it because then other people could study the patent and approximate the taste more easily. So it's a trade secret. So let's say that you are representing Coca-Cola and a new distributor or bottling company or something that's going to handle their distribution in a new region that they're opening up. And I don't know why you as the lawyer would come into possession of this secret formula, the trade secret formula, but in this type of thing where one of them has a trade secret and you as the lawyer are going to have access to it, but the other party doesn't need it in order to do what they're contracting to do. Like they're going to buy the pre-formulated syrup from Coke or receive it, a shipment of it, mix it with carbonated water and put it in bottles and send it out to stores. Let's say that's all then they can agree that the lawyer will keep that type of stuff confidential between them. And so this could happen, right? That in terms of the joint representation, they come to the lawyer together. Well, look, we're going to have a vendor agreement or a joint venture between our two companies. And if in the course of us giving you legal documents, or even let's say your conversations with the managers at the different companies, you come into possession of a trade secret, you won't disclose it to the other party. And it's okay as long as they all agree up front on what you're going to keep secret. Now, next comment, 32. When seeking to establish or adjust a relationship between clients, the lawyer should make clear that the lawyer's role is not that of partisanship normally expected in other circumstances, and thus the clients may be required to assume greater responsibility for decisions than when each client is separately represented. This is hard to understand, and I wish the ABA had been a little clearer in this, but what they're saying is that the problem is that as the lawyer representing a group, you don't get to be the tiebreaker vote when there's a disagreement, right? You don't get to have the last word for the group. And so what happens is that the clients, each of them is going to have to take a little more responsibility for decisions than when it's just you and the client. And then because when it's just you and the client, there's a lot more give and take in the conversation when the client's going to say, well, I don't know, what do you think? And you're going to say what you think, and then they're going to say, okay, let's go with that. It's a little different when you have a group and some of them are saying, we think this and we think this, and what do you think as the lawyer? And the problem is then you're taking sides in the group. So watch out for that. You need to explain to them up front that if you all get your own lawyer instead of sharing a lawyer, then you might actually be able to let the lawyer make some more of the decisions, or just go with whatever the lawyer thinks is best more, because the lawyer isn't supposed to, again, to be the referee or the tie-breaking vote when there's a disagreement in the group. Any limitations on the scope of representation made necessary as a result of the common representation should be fully explained to the clients at the outset of the representation. In other words, because you're representing them as a group, you need to limit things. Again, you need to explain that up front. I'm going to give you an example, and we're going to come back to this later when we do the next set of rules after conflicts. Very common that lawyers who are doing transactional work don't like doing trials, and they don't want to do the trial. And so if you are agreeing for a group to do their partnership agreement, draft their partnership agreement, go ahead and inform them, by the way, if at some point you guys want to get out of the partnership agreement or sue each other under the terms of the partnership agreement because you think you're getting cheated or something, I'm not going to be your lawyer for the litigation. It's better to go ahead and spell that out, put it in your documents about the, document it in writing what the scope of the representation is. I will do your draft your partnership agreement. I'll do the filings for the state. I am not going to represent you when you are seeking to enforce the partnership agreement against each other. Trial lawyers, a lot of them hate doing appeals, and appellate lawyers, a lot of them don't like doing trials because it's a very different type of legal work. So if you're representing a group of co-defendants or co-plaintiffs on an appeal, well, you better spell out to them, by the way, I'm not doing your trial if this gets remanded for a new trial. Go ahead and explain that. Why? Because if it's a whole new ballgame and a whole new set of complications to represent a group in that type of practice. Next comment, we're nearing the end here. Subject to the above limitations, each client in the competent representation has the right to loyal and diligent representation and the protections of Rule 1.9, which we haven't gotten to yet, concerning the obligations to a former client. 1.9 is about conflicts between new clients and past clients. And I don't want to spoil the surprise for you, but it's mostly focused on protecting confidentiality. It's in some ways 1.9 could have been recast as a confidentiality rule, essentially, although you're also not allowed to like switch sides in the same matter, like go from quit being the plaintiff's lawyer and be the defense lawyer in the same matter later on. And so that's kind of, see, I already told you what 1.9 is. And so if you're representing people in common representation now, 1.9 is going to affect whether you're able to represent one of them when they turn on each other. And that concludes our lecture on this part of conflicts of interest.